More importantly, we're very active in this region. We've got 9 offices across 8 jurisdictions. And even more importantly here for the UAE, we've been here for 45 years in the UAE. Our office here in Abu Dhabi opened in the 80s, and in Dubai it was in the 60s. So we've got a really long history of advising on local law, but also working with the regulators when it comes to issues like data protection and issues like that. Just to give you an example, I mean, and that can affect our customers, it can affect ourselves in a personal capacity, it can affect also our employees. And one of big data, I mean, big data sort of, I don't know how much you all know about big data, but it's basically just, high speed, high volume, different varieties of data, all now being aggregated to come out with something that's really sort of useful for the company. So they sort of mine the data and consolidate it and produce something new. So a good example is me, sort of my buying habits. So me as a person, I order pizzas every week from, Domino's, whatever, that gets recorded. They can record sort of my travel on Salic to work each day, and they know where I park in my car park. They can look on Facebook and see, me eating donuts. And you'll see a common theme here that's all quite unhealthy. And if that's me, they share my data about pizzas to another pizza company, I'm fine with that because I'm a man that likes pizzas, I'm a bit Italian. But the thing is with big data, what they do is they aggregate all these small bits of data which in themselves aren't harmful, but they create a whole picture of your profile. So then if all that data consolidated is sent to my healthcare company, so when it comes to renew my health insurance, I go along and say, hi, Joby Beretta, my age is this. They also have this background of knowledge about me, all this data that they've aggregated, and my premiums might go higher because of the number of pizzas I've had. So on that note, I'll hand over to Sara, who'll take us through the range of the laws that do exist here in the UAE.
So if you see there, we underline personal information. In the old days, personal information was very much private information. The problem is that, like Joby was saying, with all the new technologies, social media, a lot of the personal information, it's not private anymore, and it's out there for anyone to see. When we talk about privacy, well, privacy is really a human right to have the personal information private. So it's a right of us as individuals, natural persons, to lead our lives in a secluded way, protected from public scrutiny. But again, we underlined private there to show that there's a difference between private and personal, especially these days. So we have put an example here to show exactly this difference. So if there's a recruitment company, and recruitment companies, they seem to be doing this these days, if they are paid actually to provide profiles for employers. Now the question is, does this raise any privacy or data protection concerns? No?
No, I wouldn't have thought so because they are all on public domains.
So you were right. In that sense, it's not private information anymore. And so that's a matter of privacy. But from a data protection point of view, should I still be able to have the right to control the way that data is processed? Should I at least know that someone is profiling my information based on the information I'm available? Because when I put information online, I had in mind certain use which probably didn't cover the profiling for prospective employers. And this is a good example exactly to show how, although privacy and data protection, they are interconnected, because obviously the ultimate aim of data protection rules is really to make sure you can control and decide if you want to keep your things private. They really raise different issues today, because as you can see, although my personal information may be public, I still want to have a right to decide how my information is going to be used. And we will get to that because obviously certain countries, they have very tight regulation on data protection where, some of the use of the data cannot be used just freely.
But I mean, it's an interesting point. I mean, some of the countries have actually put out codes just on using social media for recruitment. So in the UK, they've got a code saying when it's appropriate to use social media, and they warn you that obviously if you make comments on, you look at someone's Facebook profile and you maybe send it to your HR manager, all that can then be disclosed as part of the data protection regime in the UK. So you have got to be careful of use of social media and the ongoing processing of that data after you've collected it as well is the issue.
And before they go into really discussing the legislation, they did this questionnaire in Europe. And one of the questions they asked was, what is that you are concerned when you put your data online. And as you can see, at the top of the list, it comes fraud. People are really, concerned about their data being used to fraudulent activities. Again, if we go back to the distinction between privacy and data protection, we can see also that, again, privacy is not on the top of the list. Although you can find it in some of the answers that were given, such as, your information being shared with third parties, your personal information being lost, or your reputation being damaged, there's also other concerns other than privacy, and at the top it comes fraud. So what is the legal framework in the UAE? Do we have any specific data protection law in the UAE, as we find in many other countries, especially in Europe? Well, the position is that there's no general data protection law in the UAE. So there's no law that regulates the way our personal data is used, processed, collected, stored, transferred to other jurisdictions. And as such, there's no also any regulator, any authority to whom any citizen could go to and complain about, for example, the misuse of data we have shared or online or otherwise. Obviously, again, this may create some concerns for us as individuals, because we don't know what to do in case we want, for example, to complain. But we will see that we are not saying that there's nothing citizens cannot do. There's some resources and there's some way of dealing with misuse of data under the UAE law, but only where such use or such processing of data is really qualified as a crime, as we will see in some of the laws. So if the use of data doesn't qualify as a crime, so there's not much really that we could do. This obviously raises concerns, the concerns that we saw in the previous slides, and especially just to mention also in Dubai, the Smart City Initiative is also something that's a hot topic at the moment, and that may also create some concerns, because we were just reading in the media some reports saying there's the Open Data Committee that is really at the moment assessing what is the data that can be open to all, and obviously we need to have data available to all, otherwise this is the enabler of a smart city. But obviously the question is, they are at the moment studying what can be open and what cannot be available, what will be considered private. So this is very interesting times, and maybe there will be some data protection rules included in the laws to be issued. Because, for example, I wonder if a citizen wants to complain about the way they categorized open data, we hope there's a way, there's a channel this can be done. But we will have to wait and see. So, UAE Constitution, this is obviously the main piece of foundation of the legal regime in the UAE, dated 71, so as you can see, long before the internet was really used. But these two articles, Article 30 and 31, they are used normally to say these are the key provisions that provide for the base of secrecy, at least secrecy of communication. But again, as you can see, Article 31, it talks about communication by post telegraph. So, this was written at a time where data security concerns amounted to simply intercepting a physical letter and opening an envelope without authorization. So it's really not fit for today's, the modern era. The other key piece of legislation which we find and normally always looked at as the base for some data protection rules in the UAE, in the absence of a specific data protection law, are Articles 378 and 379 of the Penal Code. So these articles, and again, just note the dates when this piece of legislation was enacted, again, 87, so it's quite old. Again, they could not have addressed the issues that we are looking at today. So these articles, they are actually included in the section regarding violation of secrets and defamation. And basically the first one just says that obviously it's prohibited to publish any news, pictures or comments pertaining to the people's private or family lives, even if that information is real. Article 379 is really the article that is used as the base for data protection, because this article really what it says is that it prevents the unauthorized disclosure or use of a secret that has been obtained, because of the profession, craft, situation, or art. I think with this article, and if you look at this, they are targeting again more privacy matters than data protection matters. Its scope is quite narrow. If we go back to that example of the recruitment company profiling individuals, potential candidates, does this article really help us to answer the question, like you asked, can this recruitment company do this in the real? What do you think? The answer to that is really, or the key to the answer is really a secret. Is that information a secret? It's not a secret, it was made public. But the question is, it's still an unauthorized use of that information. But, it's an unauthorized use of that information, but again, because the article talks about secret and private matters, there may be an argument for the recruitment company to say, I'm okay, I can do it, I'm not prevented from doing it under the UAE law. Then, cybercrime law. This law was initially enacted in 2006 and more recently amended in 2012. And basically, this law was really an extension of the penal codes because, again, the penal codes couldn't deal at that time in '87 with all the crimes that now can take place in cyberspace. This law, there's a lot of different teams and includes different crimes, including crimes related to IT security, political stability, but from a data protection point of view, the crimes that obviously are more relevant for this topic are really crimes that relate to data security, that relate to unauthorized access to data and misuse of that data. We can see examples of that in Article 2, where entering any electronic site or information system or network or information technology tool without permission or by exceeding the limits of such permission or remaining in it illegally. If someone does that, then there will be an imprisonment or a fine, which can go up to 300,000 dirhams. And you can see again that there's concerns about the use of data, because if from that act it results in the deletion, cancellation, disclosure, copying or publishing of the data, then the penalty is aggravated, and it can even go to fines to up 750,000 dirham. Other interesting articles in this law, it's Article 12, which again, these deal with obtaining information on credit cards and bank accounts, and obviously it also relates to frauds in the cyberspace in this sense. And the penalty, again, can be imprisonment and can also attract fines of up to 1 million dirham, depending on whether money was obviously stolen by using that information. Article 15, it's an interesting one as well, and it's again an extension of what we saw in the UAE constitution, but this time not dealing with telegraph and post, but dealing with other ways of communicating. So it's prohibited to capture or intercept any communication to any information network, and if that's done, then people can face imprisonment or fines again, which can go up to 500 million dirham. And this brings us to a question, which we know most of our employers these days, they really want to know what's the use we are giving to their IT systems, which are there for us to use to work, not to go into social media, not to post comments and so on. So one question that we sometimes are asked by clients is that, are we okay with UAE if we are just monitoring the IT usage by our employees, including emails? Well, I think the answer is quite clear if you look at Article 15. That cannot be done unless there's consent from the employees. So, there should be, it can be in the HR manuals, policies, it can be in the form of a letter, it can be in the employment contract that it's signed, but it's important that the employees give their consent and are aware that this monitoring is being done, or otherwise companies and people in companies could face the risk of imprisonment or penalty.
And it can even be done in the sort of the IT systems itself. So when you first log into an HR system, it can pop up and just give you a warning that, reminder, as per the IT policy, we do monitor your emails. So some of our clients do that as well. But then you still have to sort of balance up. It doesn't give you sort of an open right to sort of access every single one of the employees' emails. You need to sort of balance the constitutional rights of the employees against the employer's rights to know what's going on. So if they're aware of some sort of crime or some side business happening, or it wouldn't give you the unabated right to look through all their Hotmail emails that they're looking at on the IT system. So there's still got to be some sort of balance of checks and balances there, even if you have it in the handbook.
Correct.
Yeah.
And there was actually very interesting, I don't know if you've seen that in the news in July, the case of this Australian citizen that was in the end deported because she published the picture of the neighbor's car, which apparently was taking 2 slots of the disabled car park, and she made some offensive remarks. And in the end, she was found guilty of a crime exactly under this Article 21 of the Cybercrime law. Because again, that example shows that, and again, there's privacy issues and privacy concerns behind this Article 21, but there's also a data collection team, which is that lady used without any authorization information of an identifiable living person, without any authorization. She posted those pictures on Facebook.
And she even blacked out the registration plate, didn't she?
Yes.
So she even went that far and it was still deemed a crime. So that's because they said they could work out whose car it was from the surrounding picture or something.
And from the remarks as well.
From the remarks, yeah.
Was it the picture, or was it the fact that she then made remarks? If she just simply posted the picture, virtually without saying anything else, just so other people could see, would she have still got into trouble?
Well, that's a good question, but maybe just by posting that picture, if you can identify the person, the owner of the car, so you automatically have a data protection issue there because you can identify the person. And just by posting the picture, it's still visual material that carries, the idea is really to make the remark that this is not acceptable behavior, if you want. So maybe that would depend on, I guess, evidence and in the court, but potentially it would still be.
And it's even no defence that it's correct or real. So even if it's a true depiction of what happened, it's still no defence.
Exactly.
I think it was exacerbated by her language.
Yeah, I'm not sure it was quite explicit language. I'm not sure exactly what she wrote, but it was. I heard it.
I see a difference. I see a difference between that case, which is of a thing. Let's say it didn't have any comment, but it was just a thing, versus the case that's going on in the UK at the moment about a pretty barrister who complained bitterly about somebody saying how nice her picture was, and feeling victimised. And that is about a person and their appearance and all the rest of it, making her feel belittled. Whereas something like this, which is just a car, I do see a difference. I'm wondering whether somebody would bother to take action just because of that.
A car that was doing something wrong in the first place,
Yes.
needs to be there.
Yeah.
But through jigsaw identification, you can identify the owner of that car, and therefore, potentially, they feel they've been defamed. Whereas the UK scenario is not about defamation, privacy.
Yeah.
Where does sarcasm fit into this? Had she posted this picture and said, "What a lovely car"?
That'd have been a safer approach, I think.
Yes, but still, the point is really, we just should be aware that the scope is really wide, as you can see. So honestly, and I would say, and from that story on, I think I'm going to be much more cautious on, you know, the type of messages I send, WhatsApp, Facebook, anything really, because you never know.
It's about the identification as opposed to necessarily what else is being said. So I think it was exacerbated by the use of strong language. But I also think that the fact that it was identified doing something erroneous, or some would say, you know, illegal, was the problematic part of that.
You're right, exactly, because the issue really with data protection in privacy is really this ability of people to identify exactly the person that is the object of the, you know, the comments, the data being shared. Because these are really the things that's really great concern about privacy, and about protection of the data. Just to say, so obviously this can, it would be a crime, there's exceptions to it. So if the person consents, then it's not an issue of privacy anymore. And that's why, you know, if you want to publish pictures of people, you should always get their consent, and obviously preferably in writing, in case they change their minds. After all, they see the picture, I don't look nice in this picture, I should have said no. So maybe in writing is always best. And obviously, if it's allowed by law. One example that I was thinking when we look at this is, what about all the CCTV cameras out there? They are capturing images of, you know, of everything I do in the area of the camera. But obviously, that's one of the exceptions, and that's permitted by law, and that's regulated as well. It's just interesting to see that in those the laws regarding CCTV, there's only an obligation to post a sign warning you that the area is monitored by CCTV. I wonder whether this is enough for consent within. But anyway, it's permitted by law, so it would not be caught by this provision. Obligations on the employer to treat the employees with, you know, requirements of morals and decorum. The labour law also includes similar provisions. This again is also relevant for the examples like we said initially before about the monitoring of the IT usage by employees. There's also, generally speaking, the e-commerce law as well. So this law, again, is not a law dedicated to data protection, but it's just to draw your attention to this article in that law, which basically says, again, that unauthorized access to information available in any electronic records when you do your contracts online, that's also considered to be a crime, and you can face imprisonment and fines up to 200,000 dirham. So, until now we've been talking about general laws that apply, you know, generally not to data protection, but include here and there some specific provisions that are relevant. Now we will just quickly look at, and I think we have to speed up. We will just quickly look at sector-specific laws and regulations, because there are specifically certain laws and regulations which really touch upon data protection issues. So we said no general law, but pockets of regulation do exist. One example is this credit information law and regulations. They were issued initially in 2010, and now in 2014 there was also the regulations came out. And this is just a sector-specific law regulating the Al-Ittihad Credit Bureau, if you've heard of it. So this entity is regulated by the UAE Central Bank. And the idea is that this entity is going to gather all the credit information about citizens in the UAE, and third parties can come to this authority and by paying a fee request a report. So you can, you know, if you are contracting, if you are a bank and you are borrowing, you are lending money, to that person, you can access the credit worthiness of this person, of your suppliers, of your clients, whoever you are dealing with. This law is quite interesting because although it's sector-specific and only applies to data related to your, you know, credit situation, it's interesting because it really includes already most of the key things, key topics that you normally see in a general data protection law. And this includes, to start with, a general prohibition on the credit bureau getting any information about private lives, beliefs, health, which remind us of the sensitive data in data protection laws, which obviously is also for anyone to treat sensitive data. There's always enhanced requirements and permissions that need to be put in place in jurisdictions where data protection is regulated. The other rule that we see in this law is you need to obtain the consent of the data subject or the individual before a report can be issued to third parties. So it's again another topic in data protection. It's interesting that the financial institutions don't need their consent to pass on the information to the credit bureau. So your bank can give the information to the credit bureau without you even knowing that this is being done. But from the credit bureau to the third parties, that's only can be done if there's your consent. Which, in a way, I was discussing with Joby, something happened here. In a way, kind of defeats the purpose, but on the other hand, at least you feel comfortable that you know your credit information is not going to be spread unless you authorize it to be done. Then
Just add
then the other requirement we see in that law is that it says, another key topic in data protection, it says that data can only be used for the purposes it was collected. So this is something we see in data protection laws, but data protection laws, they go beyond, because normally they say it has to be used for the purpose it was collected, it has to be accurate for that purpose, it should not be kept for longer than what is strictly required for that purpose.
The interesting rider to that was when the banks were sort of going through this whole process of setting up a credit bureau, anybody denying access to their information when applying for a loan to a bank were basically giving the bank an easy out anyway. So, effectively, if you're going to a bank for a loan, the bank says, do we have your permission to get your credit background? You say no.
Makes a decision for them. Yeah.
Yes, exactly.
Yeah.
But so that's why we're saying it kind of defeats the purpose, but in a way, maybe raise red flags to the bank, because if you don't feel comfortable sharing your credit information. Similarly, in Dubai Healthcare City, there's also a data protection law there, but only applies again within the boundaries of Dubai Healthcare City, and it's very similar to the DIFC law, but there's a difference because this law is really sector specific and only relates to data related to the physical or mental health of a patient, so nothing else, just that data. And same rules also regarding transfer and so on. Also, as sector specific laws to be aware of, telecommunications law. So the telecommunication law, basically, the aim is to regulate the provision of telecommunication services, but it also includes... Yeah, okay, so we were talking about Healthcare City. Medical liability law, it's again another sector-specific law where you find provisions saying that obviously your doctors have to keep your information private. Joby, do you want to touch on 2four54?
Yeah, I mean, similar to the old TCOM DCCA, you guys here in 2four54 have the conduct code. Thank you very much. Content code, and there's a provision in there. I think provision 7, isn't it, that deals with privacy issues. So if you're filming, so I presume you guys are sort of aware of that already. We were going to go to the web page and just put it up on the screen, but is everyone sort of vaguely aware of that? I mean, it's quite specific to more sort of filming, use of certain issues on sort of funerals and privacy, and it's very useful, detailed code. We find it. I think it might have been based similar to the UK Ofcom stuff, or where did it? Yeah, and that's really good because it gives concrete examples. I think everyone should be aware of that definitely and know their ways through that if they're active here in 2four54 obviously. And there's a similar code that's based almost identically on Ofcom. I think TCOM just cut and pasted it from the Ofcom provisions, and that has similar codes, and it's now called, they've rebranded as the Dubai Creative Clusters Association. Yeah.
Again, you could face imprisonment or fines. We just put, this takes us to an example that we have every day when we call a customer line service, and we hear this message saying, this call may be monitored or recorded for training purposes. I wonder how does this fit with these two articles, because am I giving consent just by being informed that it's going to be recorded or monitored? Well, I think, maybe the companies, because they really do that, maybe they take the approach that, if you continue with the call after being informed, then this could be deemed consent under the general rules included in the civil code, where silence, depending on the acts, may be considered a declaration. But honestly, if I was in charge of these companies, I think I would take a cautious approach, especially because we are talking about crimes here, and I would probably give the option of the person to, give authorization for that use of my call to be done. Because you can continue the call, but you can choose, no, I don't want my call to be recorded or monitored. Also sector-specific, still the TRA policy on spam, direct marketing. If you are like me, you are probably very annoyed every day to receive millions of SMSs on your mobile phone. Obviously, that raises concerns about advertising and marketing laws. We obviously are not touching those. But from a data protection point of view, what this raises is that, well, if I'm receiving this message somewhere, and somehow there are companies harvesting my address, phone numbers, and selling it or passing it on for all these people to be sending me messages. And I would like to have a right to be able to control, because my number is my personal number, it's still personal information. Again, we don't have a general authority regulator where we can go to, but at least TRA has issued these policies, and it's allowed there and obligated to take reasonable steps to try and avoid spam through their networks, irrespective of the spam being sent by themselves or by third parties. And they are also, under an obligation to raise awareness on the resources, on what you can do to avoid spam. And apparently there's certain numbers that you can send to stop them. I haven't tried them, but again, hopefully they will work. And I guess that's it from me.
Okay. The TRA have come up with their own rules, and there was a new one in 2014 dealing with consumer privacy. So it's been dealt with on a sector-by-sector basis at the moment. But for the customers, your customers out there, they've got a concern. If I hand over this information to you guys, what are you going to do to it? What we're saying is, and what we're actually seeing in the market, is companies are sort of imposing their own conditions. So they go, okay, well, it's not a legal requirement by law, but we're going to put in place a privacy policy. And then you can set that as high as you want. I mean, in terms of the actual UA law requirement's quite low benchmark here compared to the rest of the world. You could set it there, or we're seeing them set them sort of higher up to be in line with other jurisdictions. And that's what we sort of come on to in terms of the sort of policies, practical steps. As Sara pointed out, really it's only the UA law is only covering sort of dealing with the privacy of information and the public disclosure of that. It doesn't tell you how to store it, doesn't tell you how long to store it, when you need to delete it. Can you transfer it? Do you need notifications? None of that's there in the law at the moment. And this is the thing here, yeah. So we are seeing companies here saying, okay, let's take the UK law and use that as a benchmark. And they're not saying it's mandatory. I've seen some companies say, okay, we'll use all reasonable endeavours to meet the UK law. So this is what we're aiming to achieve, but there may be things in practice that we can't do that. So there's no point to set yourself a mandate that's so high that's not required by law that if you fail, there's an issue. So it's just a sort of good guidance or a good sort of code of conduct. And that helps you, and we'll come on to that, in sort of if you are dealing internationally. So if you've got a subsidiary in DIFC, if you've got a subsidiary in England, you're going to need to meet that standard there anyway. So why not use that as a sort of group standard? So what we often say, so if people do come to us and say, okay, I do want a privacy policy, what should I put in it? If there's no sort of real requirements by UA law, what is that good practice? And this is a Madrid resolution which was signed up by over 50 data protection commissions around the world. And they all said that these are the sort of the key things. And you'll see this in the DIFC law and in the English law, that the data has to be processed lawfully fair. You have to take a proportional approach. You don't take too much data that you don't need. You have to specify the purpose. You have to make sure that the quality of the data is, it's correct. People have the ability to correct the information held on them. You need to be open about what you're going to do with the data, tell them what purposes it's going to be used for, and a certain amount of accountability on that data in terms of sort of minimal requirements for the technology so that it's secure, so that it's not going to be sort of lost or accessed. So they're sort of key ones which we always say to people, keep those in mind. And again, they can just be sort of fundamental, principles that you want to achieve, not a legal requirement to meet them. You don't need a legal requirement to meet them here at the moment. And then there are loads of different sort of industry-specific sort of white papers, discussions on if you're in telco, you should deal with privacy in this way. If you're in media, it should be this way. Credit cards, obviously, really sort of at the high end of the security requirements. So if you are in that a particular sector, just to keep an eye out for any sector-specific, which here again is the twofour54 regulations. So in terms of recommendations, takeaways, I think this is our last slide. I mean, I think probably number one recommendation would just be to educate your staff on the law. So, I mean, you've seen, and Sara's sort of pointed out, there are some quite harsh penalties. So the law is quite a low sort of, milestone to meet. But if you get it wrong, they're quite harsh. You can end up in jail, or your general manager is probably the one that's going to end up in jail. And you can get fined up to 1 million dirhams, we saw, of the law here. So one is just educate your staff. There should be at least a one-pager or send them a link to, we've got a few articles we can send you, and just so people in your companies are educated about what the law is here in the UAE, so you don't fall foul of it. And then the second is then think about building on top of that. So there's the UAE law, but think about the best practices. Look at some of these common concepts, and again, these are just in the Madrid resolutions. Think about not only for yourself, but also when you're dealing with suppliers. So if you're handing out your data, so I give the example of you using a data warehousing company, or you're using a third-party marketing company to send out emails for you, put these sort of obligations on them. Because if you just say, most of the contracts will say comply with all applicable laws, and again, that's setting a low benchmark for them. But why not say you have to process it fairly, you have to process it in accordance with our instructions, make sure you've got the security in place so it can't be accessed. So we're seeing that more and more, those sort of clauses going into contracts when it's not a legal requirement to do so. Said about each sector has its own ones. This is another one. So even now there's no laws in place. What we're seeing is people are designing their systems so that they get this consent. So I said a lot of the laws, it's fine as long as you have the consent, but how do you obtain that? And so in terms like I used to be in-house in a sort of hotel company here in Dubai, and it was how do you get the consent from the different touch points? So when the guest comes up and they sign in at the beach club, there's a consent issue on that. When they sign up online to get marketing materials, there's a consent build up to that. When they go drop the kids off at the kids club, there's a separate consent. And it's all sort of every touch point you come to, and that might not apply to your business, but where are your touch points with your customers? So do they sign one contract at the beginning? Are they on your website? Can you get their consent at that stage? So just think about every interaction you have with your customer and where you can potentially get this consent. And then another one is just, this is one that really, as an individual, this is what you want the rights to complain if some data is wrong. You want the rights to sort of access the information or object to certain key data. Again, this is optional. Totally optional. There's no requirement under law at the moment, but this is a fundamental right that we would have elsewhere in the world. And so what we're saying is sort of build that into the systems now, so that if a GCC-wide data protection law does come in soon, you're already in place, you're already ahead of the curve. If people are looking at your business for potentially acquiring it, they're going to look at things like your privacy policy. They'll ask for that as part of due diligence. So it's getting more and more important again, even if it's not a legal requirement. So that was the end of our talk. I mean, I know we've pretty good timing, but I mean, we're happy to take questions now, or we're happy to take questions outside. If you want to ask one-to-one, it's totally up to you guys. I know you've all got work to go to, so your call. If there's any general questions, we're happy to take them.
Are we able to get a copy of the presentation, some of the references?
Yeah, definitely. We'll if you get our card or something, and if you could hand it over, we'll email it around. As long as we've got consent to sort of email you, But we'll change cards afterwards. And there's a few articles as well we can send around if anyone's interested on sort of big data and what if we get another one on the smart cities, stuff like that. So.
Thank you.
Cool. Thank you. Thank you for coming.